You're ever in a situation and a lawyer tells you to take the fifth, go ahead and do that right then. Take the fifth. Take it. Take it. Oh, look at that. Look, one of my favorite beefs with TV and movie courtroom scenes is not ruined here. My name is Mark Breyer. I'm a trial lawyer. Not like a fake trial lawyer or not like a lawyer on TV that says they're a trial lawyer, but they don't actually go to trial. I actually try cases, certified specialist, blah, blah, blah. Here's what it means. I spent a lot of time in courtrooms, usually because someone else's mistakes hurt another person that I'm representing. Let's look at some of these clips from Suits. Obviously, everyone knows what happens in Suits is not exactly right, but when you watch scenes like these, do you know what's real and what isn't? Do you know where the writers get it right and where they've gone totally off the grid? So let's have some fun together. Let's look at some of these clips. Let's figure it out.
When the accident occurred, you were on your way to the medallion auction. When and where was this auction to take place?
9 a.m. City Hall.
According to the police report, the accident occurred at 8:53 a.m. That means you only had 7 minutes to get downtown in rush hour traffic.
Here's where the writers got it right. Using timelines is a very common way to cross-examine people. So if you're ever a witness, you might want to be aware. You can't change what you think happened, but you might want to at least know that maybe how you remember it may or may not line up. And also, if someone jogs your memory before you take the stand, you may remember why that is, that the timeline doesn't seem to otherwise fit.
Objection, irrelevant.
I believe when I made the same objection, you told His Honor it was highly relevant.
Here's the way it works. You only talk to the judge as a lawyer. All the time in these court shows, the lawyers argue with each other. Not the way it's supposed to work and generally not the way it works. You stand up and you say objection. I say to the judge why that objection should be overruled. I don't turn to the other lawyer and tell them why the objection should be overruled. And not only because it's unprofessional and not allowed under the rules, but the person you're arguing with is on the other side. They're never going to go, oh, good point, and sit down. So you're always talking to the judge in court.
Overruled.
Of course, that was a really interesting scene because if I just saw that right, the witness objected. Yeah, that's, you probably know not how it would normally work. But this is Suits, and I don't really know this episode or this show.
These things never start on time.
Then why was the first medallion sold at 9:03 a.m.?
Ooh, discovery, y'all. So here's the way it works. The difference between a great lawyer you hire and an okay lawyer is not just what they do in a courtroom. It's the work they put in beforehand, the organization they have to put in the work beforehand. If your lawyer doesn't know what to look for and how to find things or who to talk to figure out how to get the right things, he would never know what time the first car was sold. He just has to sit there and try and cross-examine without that ammunition. So if you're ever interviewing a lawyer and you're like, which lawyer do I hire? Get really, really specific. Tell me an example of a time you tried a case like mine. Tell me something you found that you think other lawyers would not have found. Tell me about a time a judge overruled something for you in trial and you had no idea what you were supposed to do, but you found a way to win anyway. Get specific. Anyone can talk over your head that went to law school if you didn't and sound like they mean it. But when you get specific, it's a lot harder to dance.
You were scared your chance at a medallion was going up in smoke, and you ran a red. Then you used the accident to paint me and Ray Benghazi as a couple of scapegoats.
Number one, that question is objectionable because he asked two questions in one, so it's a compound question. Two, you're the lawyer, you are not the party. So when he said you made me and my client the scapegoat, it's never about you as the lawyer. You made my client the scapegoat. You're not a party to this case. You're a lawyer fighting for a party in the case.
What color was the light?
I take the fifth.
You can't take the fifth, Mr. Santana. This isn't a criminal case.
Aha, but you can take the fifth in a criminal case, guys. Is it impossible watching clips with me when I point out everything? Listen, this is not me ripping the show. It looks like a good show, a good scene. I'm just trying to point out some of the differences, what happens in a courtroom, what you see, even in a good show that everybody loves. You cannot take the fifth in a civil case unless you could face criminal charges. Therefore, there are many times that people I'm going against in particular take the fifth. Most common example, drunk drivers. I'm going against a drunk driver. Drunk driver hurt my client. I get into a deposition with the drunk driver. Drunk driver, we're in a civil case. And, you know, in this case, oh, you can't take the fifth. It's civil. You can take it in relation to potential charges against you. Now here, it's going to be up to the judge whether the Fifth Amendment applies. And here's why. Running a red light with minor injuries is generally not criminal. But is the judge going to be willing to say it is not criminal? On top of that, if you take the fifth in front of a civil jury, one of two things, it's not a criminal case. In a criminal case, you don't have to testify. But in a civil case, the question is, what state are you in? In some states, the jury is not really guided much at all, but they're probably not going to like you took the fifth. In other states, Arizona is an example, you take the fifth, there is a presumption that you were taking the fifth because what you say was bad for you. You can take the fifth, but there are consequences to doing it.
You claim to love our legal system so much. Answer the question. What color was the light? What color was the light? Your Honor?
Answer the question, Mr. Santana.
We all know it's about to happen, right? That's never going to happen. Almost never in almost anyone's career. First of all, the guy tried to take the fifth about running the light. The judge never even ruled on it. The lawyer said you can't take the fifth, and they just kept going. That doesn't happen. But beyond that, one of the issues you're dealing with is you have a lawyer right here who's going to get him to say what he ran the red light. So now he just committed perjury in the entire trial when he said under oath to a material fact that he didn't run a red light. How many people do you know that would on the spot, just because they're being questioned, admit that everything they had said, not just in this courtroom under oath, but in the pretrial deposition under oath, in the pretrial discovery under oath, to friends, to family, apparently to the media, what color the light was, how many people suddenly on the stand are like, all right, everything I said was a lie, and go ahead and get a big judgment against me.
Not a great plan.
That would be good if people could be that honest, but
It just meant so much to me.
Your Honor, can I sidebar with opposing counsel? We can roll the dice with the jury, but I'd rather settle.
How much do I have to pay?
Nothing. You take responsibility for the accident, and your insurance company makes Ray whole. In return, I waive my right to collect legal fees.
it's a beautiful moment, right? Here's the thing. Obviously, this guy must be representing himself, hence the whole back and forth, which I didn't know. But let's talk about this for a second. The other lawyer just told him, your insurance company is going to handle this as long as you agree. He can't do that. You don't know what the insurance company is going to do. You can think you know what the insurance company is going to do, but that is a moment where you would have to get the insurance company involved to find out if they're going to do what he's saying. And this guy's been representing himself in the whole trial. He has violated one of the covenants of the clause. So when you have an insurance contract, a policy is made up of a bunch of legal clauses. There are things you have to do. One is the cooperation clause. You have to cooperate with your insurance company. You can't represent yourself all through a case, and then when it goes badly, go, hey, insurance company, you come handle this. No, you violated the cooperation clause, dude. You are out on your own. All right, scale of 1 to 10. 10 is, that's exactly what a real world courtroom looks like. 1 is, you got to be kidding me. There's nothing like it. 5 is typical TV show courtroom scene. I'm going to give that a 6. They did a lot of good things similar to a courtroom. The things they took liberty with were to largely move the discussion forward. I'm not going to get hung up on it. I thought it was a pretty good courtroom scene if you understand what they have to do in this kind of setting. All right, next up.
You read a book that says you don't let the jury sit with things. The only problem is...
We're not inside of a book.
I don't want to seem defensive.
Harvey, we still have a ton of shit to hit him with.
Were you in there? They're buying what he's saying.
Then we make them buy something else.
We got a pair of aces. If the jury believes that Cameron's got 3 of a kind, we're not going to win.
We can't go after Steven.
Cameron won't go after Ava if I can convince him it was Steven.
You went to Cameron?
Yes.
And you're going to trust him?
I'm not sure we have another choice.
All the time in trial. At every break in trial, the lawyers on the team are getting together and making tactical decisions. And sometimes this is a strategic one, right? It sounds like they're totally changing the game based upon what's happening and what they see the jury doing. The first one makes perfect sense. The second one is dangerous. Very few people can actually read a jury well. My dad told me a story. He was on a jury once. It was a criminal jury. There were 12 people. He said 12 out of 12, he got them wrong, including himself. The side he would have thought he would have been on was different than he was on. And in a criminal case, in most states, including Arizona, which is where he was on a jury, you're not allowed to talk about the case to the end. He was surprised already where he fell. Everyone was on the opposite side of where he would have thought they would have gone. Trying to read a jury is very tough, but this kind of stuff happens all the time. The decisions made on the fly during trial have a huge impact on wins and losses.
You're thinking what I think you're thinking. Don't.
I'm thinking I'd like to rip your face off.
You get Mariga to point the finger at me, I will point it straight at Ava.
Stephen, Jessica doesn't respond well to threats.
Oh, I don't make threats. I give warnings. You've been warned.
That happens less. Although there's a famous moment between counsel in the O.J. Simpson trial where the interaction allegedly between F. Lee Bailey and Christopher Darden impacted what the state of California chose to do in the case. But usually there's a lot of discussion amongst trial counsel on the same side, less back and forth threats between attorneys. By the way, so scale 1 to 10, I'm going to go with a solid 7. That kind of discussion is one of the things you never really see talked about, and it's a big part of actual trial work.
Could you please state your employment history prior to becoming a legal secretary?
I was an actress.
Were you able to make a living at that?
No. I worked as a waitress to supplement my income, but I don't see what that
And how
has to
much do you make now, Miss Paulson? Somewhere in the 6 figures?
Yes.
I don't know what's going on in LA, but 6-figure legal secretaries are not a common thing in most parts of the country. That's if I heard it right, and I thought they said she was a legal secretary. Maybe I got that wrong.
Miss Paulson, I'll ask you again. Did you destroy evidence on that case? And I'll remind you that you're under oath.
Objection. The document he's referring to was fake. It's not illegal to get rid of fraudulent documents.
Did she know that when she destroyed it?
It doesn't matter. So unless he plans to prosecute the witness for doing her job...
I plan to ask the witness questions. I'd like the chance to do that.
See how these two are going back and forth with each other and the judge isn't saying a thing? Highly unusual. If you don't like what's happening, you turn to the judge and you make your objection. You don't like the objection, you turn to the judge and you explain why the objection is wrong. You don't argue back and forth between you and your adversary, not only because it's unprofessional, because you're never going to convince me, no matter how strong you argue, that you're right. The judge is going to have to make the decision. In fact, that's what the judge is pretty much paid to do.
Miss Paulson, were you fired during the Coastal Motors trial and then rehired 1 week later?
Yes, but...
And since then, you've become your firm's chief operating officer.
See how he cut him off? Yes, but this is very much in the discretion of a trial judge. Some trial judges, if you stand up and say, Your Honor, would you let the witness finish, will instruct counsel and cross-examination to allow the witness to finish. Some will turn and say, you have a chance on redirect, and on cross-examination, you can limit the witness. Now you have a different issue. If you cut the witness off, do you look to the jury like you don't want to hear the truth? But if you don't cut the witness off, do you lose the ability to actually get out what you want to get out and control the examination so the jury can actually hear what you believe is the truth and not let the witness waste an hour of their life and never actually get to the point? The decisions you're making on the fly in cross-examination, based in part on what the judge is doing, based in part on what the jury is doing, how important is this witness, relying on your experience, these are critical moments that are happening every day in trials across the country.
You're not a lawyer, are you?
You don't need to be a lawyer to be a COO.
All right, take back what I said. There are COOs all over the country making 6 figures. That's about right.
I know how it works.
Oh, so do I. By breaking the law and then rewarding the people that do.
That's a lie.
Well, then how did you get your promotion?
Interesting. She turned to the judge and said, that's a lie. Most witnesses would either say it to the person attacking them or to the jury that they know is judging them, not usually turning to the judge, but you see that more in film than you see in actual courtroom.
When you're not qualified and they're both pretty distasteful.
Objection, that's inflammatory.
Answer the question.
Objection, that's inflammatory. Probably objection badgering. Probably move for a sidebar and say, he just accused her of sleeping her way to the top and you should hold him in contempt, Your Honor, and refer him to the bar. That would be appropriate, by the way. And instead, as often happens in TV and the movies, we didn't wait for the judge. The lawyer just decided that she's going to answer the question.
I asked for it.
You asked for it. Well, you know, if that's all it takes, maybe I should ask Mr. Spector for a pony. Except I don't think that's all it takes. I think it takes destroying evidence, getting fake fired, and a little acting ability to pull it off.
This is one of the things that happens in so many courtroom scenes that is not allowed at trial, but it's easy to fix with an experienced trial lawyer. He just gave an entire piece of his closing argument right there. He didn't ask her a question. He wasn't even trying to ask her a question. He just jumped up and made his point. No, you get to make your points like that without asking questions in opening and particularly in closing. That's it. You don't get to just stand up and make your big point to the jury in the middle of a cross-examination. That's reality. Here's the other reality. Really experienced lawyers who are comfortable in front of the jury would do those same things in a question. Instead of saying, I think that you're lying and you destroyed evidence to get to the top. Not allowed to say it. But what he could do is instead of turning to the witness, turn to the jury, unless the judge cuts him off, and say, so in fact, the way you get to the top is not just asking, it's by destroying evidence, right? You're telling the jury the same thing, but it's a question. No matter what she says, you don't even care. There are things she can do to try to minimize the damage, but now you've done it within the rules of evidence.
He's testifying.
Yeah, well, then I'll wrap it up.
Ooh, look at that. I take back what I said. The objection was correct that he was testifying, and I gave that whole speech, and boom, the writers of this scene got it right. You cannot do that. He should move to strike, and he should probably request a sidebar if this has been happening saying repeatedly in trial.
She was willing to destroy evidence in that case. She's willing to do it in this one. And that is why the memo referred to in that article no longer exists.
Most judges, the majority, but it's a split, do not like speaking objections. They want you to do your objection in one word, and if they want more, they'll tell you they want more. What that lawyer just did is appropriate in many courtrooms, but not most. And that is, he had a long explanation as to why he was making the argument he was making and should be allowed to make it. The reason judges often don't like it is because now the jury's hearing his argument, which really has nothing to do with the jury. It has to do with whether this evidence can come in.
Your Honor, I've heard enough. This case is moving forward, and I'm allowing that article to be admitted as evidence.
All right. Scale of 1 to 10. Good, solid 7. Not easy to do in a courtroom. Excellent job. All right, let's do one more together.
In 2 years, you handled 18,300.
Oh, look at that. Look, one of my favorite beefs with TV and movie courtroom scenes is not ruined here. You guys see that gallery back there? See how it's empty? Welcome to a real world courtroom. When was the last time you just decided to get up and go to a court? We can't even get people to go to the movies anymore because of flat screen TVs. And yet somehow everything that's on TV or in the movies is filled with people watching it happen. No, it's not. Even many high profile cases that are covered on the nightly news, almost nobody's in the back that's not somehow connected with a party or the lawyers involved.
But I always planned on ending up at her firm and paying her back by earning that firm outrageous settlements. How am I doing?
Could do better.
You two think that this is a joke?
Argumentative.
You're damn right it's argumentative.
Once again, they're going back and forth on the objection. The judge doesn't say a word. Judges are literally waiting around to rule on objections. Probably a super boring job if you just let the lawyers argue between themselves.
In your capacity as assistant district attorney in the county of New York, did you knowingly suppress evidence in violation of the ABA rules of conduct, the NDAA standards, and the New York State Bar Rule 8.4, Section C?
My client would like to exercise his Fifth Amendment rights at this time.
Just so you guys know, at least in many states, your lawyer cannot have you take the Fifth. Your lawyer can advise you to take the Fifth. So what would have happened there, she would have advised him to take the Fifth. And then at that point, he would have to say yes or no. Little word of advice. If you're ever in a situation and a lawyer tells you to take the Fifth, go ahead and do that right then, immediately. No thought. Don't worry about it. You can always undo that later and testify. If your lawyer is telling you to take the Fifth, unless your lawyer is someone you have no reason to think has any idea what they're doing, take the Fifth. Take it. And then figure out later. Reality, that's tough because that's not a regular courtroom scene. And what they're showing is not a typical situation. So it's a little harder to gauge on the scale of 1 to 10 that I've been using, but I would give it a solid 6. There was not even a judge involved in the scene. It was like a 3-way conversation. That conversation could have easily happened not in a courtroom, but as a courtroom scene, I'm going to go with 6. Still a better job than the average courtroom scene in movies and TV. If you have ideas on what you'd like to hear me talk about, if you're like, man, I'd love to get a trial lawyer's view on a certain courtroom scene you like, or not even a courtroom scene, I would just really like to get some feedback from someone who's actually stood there and done this stuff. Make sure you comment. We'd love to hear your comments, love to respond to the things that you request. Be sure to subscribe for more. Let us know. We're looking forward to hearing from you.